Okay, good morning. We've got 2 hours and lots of information. So again, thanks for joining me and we will get started. First of all, just some housekeeping matters. Disclaimer, nothing in this presentation should be interpreted as legal advice, and you are advised to consult with a licensed New Mexico attorney if you should have questions regarding any of this material. So what are we covering today? Well, everybody's heard a lot about these new and revised NMAR forms and our new ORW process, which I like to call the ORR process now. So we're going to talk about all of those. We're also going to talk briefly about hybrid appraisals, E&O claims, legal hotline issues, and some case law. And as usual, we have a lot of information to cover and not a whole lot of time to do it in. So to begin, we have new and revised NMAR forms that have been released to the vendors, but they're not live in the libraries yet. And of course, the question we get all the time is, when are they going to be live? And the answer to that is we're not sure, because once we give them to the vendors do whatever magical things vendors do. And unfortunately, we are not able to really nail them down on a specific date that they're going to be live in the library. We did send out an email a couple of weeks ago with a video. I hope you all have had a chance to watch it. And if you haven't, I'm covering all of that today, but I also advise you to take a look at the video. Also PDFs of the forms. We will be probably sending out those forms again because there have been some small minor changes to those that we'll talk about today, but they're not live in the library yet. And we don't expect you to use them until such time as they are live in the library. I get that question quite a lot. How, when do we start using this new process in these new forms? Now, I will say that there will be a period of time when the new forms are available in the library, but you may be using a purchase agreement that is not the new purchase agreement. So the new purchase agreement references all these new forms, but the existing purchase agreement obviously does not. And if you go under contract with an existing purchase agreement and in the interim between there and closing, the vendors post all these new forms, then the question, of course, is, what forms am I supposed to use? Because the ORW will be pulled from the library when these new forms are posted. So the answer to that is you use the new forms. And even though the purchase agreement references the ORW form, the new forms can be used with the existing purchase agreement. So you can use the new forms with the existing purchase agreement for the interim. And then, of course, once you start using the new purchase agreement references all of the new forms. So what are the new and revised forms? Well, we have a waiver of inspection contingency form, which is new. Currently, we are addressing the waiver of inspection contingencies within the purchase agreement, but we felt like that was not adequate or not the most prudent way to address that. And so we have a new form to deal with that. A notice of objection form, the 5141. We have a response to notice of objection, which is 4152. And the objection resolution addendum, which is 5143, and the notice of all the unresolved objections, which is a brand new form as well. And all of those forms are part of this new process that we're going to talk about. We've made a change to the listing agreement, form 1106. The time that, I'm sorry that I should have updated this because of the time I thought it was pending EC approval when I gave this presentation live at the NMAR annual conference about a month ago, but it actually has been approved by the EC. So we'll talk about that one small change. The residential purchase agreement has had to be revised to accommodate this whole new process, plus some other changes. So we'll go through those. The appraisal contingency waiver addendum has been revised, and that has also been approved by the EC at this point. A couple of information sheets, a service animal, assistant emotional support animal / service animal, information sheet, mostly used by property managers. That has been approved by the EC. And we also have a new information sheet on recreational marijuana that has also been approved by the EC at this point. So let's get started on this new objection response resolution process and forms. As I said before, it replaces the ORW. So what we think of the objection resolution waiver form in that process is being replaced by this new process. And of course, whenever we make changes to the forms, the question becomes why? Why was this necessary? I'm sure that some of you think that we make changes to the forms just to make changes to the forms, but we really don't. There's usually a valid justification for making the changes. And in this particular case, the change was tremendously warranted. So As you know, our current ORW form is initiated by the buyer when they're making their objections to inspections or surveys or appraisals or anything that they're making their objections to. That gets signed by the buyer and sent over to the seller. And then the seller, of course, responds and the buyers go back and forth until they come to resolution. Now, a number of years ago, we modified that form and we pushed the parties off of that form for purposes of negotiating price modifications and seller concessions. And over the years, I've gotten the question, since we made that change, I've gotten the question, why can't we negotiate those numbers on that form? Well, that form is not always making its way to the lender, which is problematic, because if you think about it, no matter what you're doing on that form, whether you're doing a price modification or you're doing a seller concession or you're doing repairs even that the seller is agreeing to do for the buyer, those are modifications to the purchase agreement, because as the purchase agreement is written, the seller is not required to do any of those things. They're not required to reduce the price. They're not required to give a seller concession. They're not required to do any repairs in order for the buyer to have to buy. So when you start saying that the seller is required to do any of those things as a condition of the buyer having to buy, you have amended the contract, the purchase agreement. And because you've amended the purchase agreement, that amendment needs to be going to the lender in the event that there is a buyer involved. And I don't think it was necessarily a problem with the form, but I do think that there was a problem. There was a disconnect between the form and the education that went along with the form, because what was happening is that unfortunately a lot of brokers and buyers and sellers were negotiating price modifications and seller concessions and repairs on that form, and yet that form was not making its way to the lender. And whenever you have a modification of the purchase agreement that doesn't make its way to the lender, you have the potential for mortgage fraud. Now, I've heard brokers say a number of times that, if you negotiate something on that form and you get it to the lender, it could impact the deal. It could create a problem for the lender. The lender may say, well, we're not going to close without that repair being done. Or, I don't like the fact that the seller is giving so much money back to the buyer at closing, and that's going to create a problem with the loan. If you keep information from the lender that helps them make a decision as to whether or not they want to make the loan or not make the loan, that is the definition of mortgage fraud, and there's just no way around it. If the document doesn't make any difference at all, then send it to the lender every day. If it does make a difference, then it must go to the lender, because again, it influences the lender's decision and they have to have all the information available. Another thing that I'll say about mortgage fraud, and I wrote an article that's coming out in the next week or so in the NMAR Voice all about this. And so I encourage you to read it and to share it, because I think that, again, there's a lot of confusion as to why we had to make this change. And in part, that article explains it. But a lot of times, and I've heard this on the hotline a number of times over the years, the lender or the person that you're dealing with on the other side of the desk will tell you, I don't want to see that document. We don't want to hear about repairs that have to be made. You have to remember that that person on the other side of the desk or that person on the other end of the phone that you're dealing with, if they're telling you that, they are not the person making the decision about whether or not to make the loan. Those people are called underwriters. And as I said at my legal update recently, underwriters are these elusive people that we don't, I don't think we've ever met an underwriter. We don't know what they look like, but we know what they do. They make the decisions as to whether or not to make the loan. And so even if you have what you think to be the lender sitting in front of you saying, we don't want to see that document, we don't want to know about those repairs, remember that that person is not the person who is making the decisions about the loan, and keeping the information from the person who actually makes decisions about the loan is, again, mortgage fraud. So we really needed to kind of adjust the way we approach this whole topic in order to avoid the potential for mortgage fraud. And the solution is this new process and these new forms. And there was a bit of I wouldn't say it was a compromise, but at the end of the day, the only thing that has to go to the lender is any agreements or amendments to the purchase agreement. So that whole process leading up to that final agreement between the parties as to how to resolve the buyer's objections is just a negotiation process. And if you're not amending the contract during that phase of negotiations, then those aren't documents that have to go to the lender. Again, what has to go to the lender is any ultimate amendment. So as we walk through this process, you'll see that the objection forms, the response forms, they're only signed by one party. The buyer on the objections, the response forms only by the seller or by the buyer, if the buyer is responding as well. And those are only signed by one, either the buyer or the seller, never both. And because of that, they're not amending the contract. So they don't have to go to the lender. But what does have to go to the lender is the final resolution addendum that we'll talk about. So what is this new process? So we have this notice of objection that is signed by the buyer, and this is the buyer's wish list. These are all the things that the buyer wants to see done as a result of their inspections, or as a result of the seller disclosure form, or as a result of a survey, or whatever the issue may be. And only the buyer signs that. And then in response to that, the seller will create a response, a note to the notice of objection. The initial response is only signed by the seller. It's not signed by the buyer. Again, we're not amending the contract. We're just negotiating. And then if the buyer agrees with that, then the parties are going to create a resolution addendum. But if they don't agree with that, then the buyer will have an opportunity again to pull their own response form from the library, a brand new response form, only signed by the buyer, going back to the seller, telling the seller what the buyer would like to see in response to what the seller had told them. And this goes back and forth. This process goes back and forth until such time as the parties have come to a resolution, at which time the parties will fully execute, buyer and seller, a resolution addendum, again, signed by both parties. It is an addendum or an amendment to the purchase agreement. And it doesn't matter what you call it, and whether you call it an addendum or an amendment, but it must go to the lender. I will just quickly say something about amendment and addendum. For years, we've had both of those in the library, and for years, there has been a tremendous amount of confusion as to whether or not to use an addendum or an amendment. And everybody kind of had their theories on when to use an amendment and when to use an addendum. Some people thought you used an addendum before the contract was formed, right, at the time that you're sending the offer over. And then after you have a contract, then you're using the amendment. That was a fine way to look at it. Other people thought that the amendment changed things that were already in the contract, whereas you would use an addendum if you were adding something that wasn't already addressed in some way in the contract. Again, a fine way to approach amendments and addenda. However, the problem was that people were getting very hung up on whether it was an amendment or whether it was an addendum. And there were circumstances where, for example, a broker wouldn't even submit the form to their client or their customer because they felt like it was written on the wrong form. It shouldn't have been written on an addendum. It was really written on an amendment. There were also QBs that wouldn't even pay their ABs because they would find in the file that there was an amendment instead of an addendum, and the QB was very sure that it should be one rather than the other. Anyway, it was causing so many problems that we have decided as an association, the Forms Committee has decided that we're going to just do away with amendments in our forms library and call everything an addendum, because at the end of the day, both an addendum and an amendment can do the same thing. An addendum can change something, add something, take away something from a contract, as can an amendment. So in the meantime, until that transition fully occurs, please keep in mind that both of those forms, was the addendum and the amendment, can do all of those things. We thought we had kind of fixed the problem by putting on our purchase agreement addendum/amendment, but what we were finding is people are circling one or the other as if it's, as if they have to make a choice as to which one they're submitting. So again, remember, in the interim, it doesn't matter. They both can do the same exact things. Moving forward, you will be seeing no amendments and just addendum in our library. So what is the notice of objection? It's the first form that in the process, and it's, again, initiated by the buyer in response to their objections to whatever it may be. Now, there can be multiple notices of objections. So there could be just one notice of objection if the buyer has accumulation of all of their objections. They certainly could put it on one form, but they could have multiple notice of objections. They could have a notice of objection for a survey and for a seller disclosure and for an inspection. So they could have multiple notice of objections, which is why we're going to number those. And you see the number at the top of the page for purposes of numbering your notice of objection. And then you'll see this language on the next two forms, the notice of objection and the response form. The first bullet in the box, which says this is not an agreement. So again, it's only being signed by the buyer. So it's never going to become an agreement. The minute the seller should sign this, and then you'll see on the second page when we get to it, there's no place for the seller to sign it. So I don't even know how that would happen. But in the event that the seller should sign something on this form, then we have created an agreement or amendment. And we're trying not to do that, because as long as we're not amending the contract, these are not forms that have to go to the lender. So we tell everybody this is not an agreement, and there's not going to be any agreement between the parties until you execute the resolution addendum. So we're telling them that up front, but we also go on to say that it is important that the buyer consult with the lender before entering into a resolution addendum, because in the event that they enter into the resolution addendum, depending on what that resolution addendum ultimately does, whether it be price modifications, seller concessions, or repairs that the seller has agreed to make, that could have an impact on the buyer's loan. So if the buyer is getting a loan, we're telling everybody to consult with your lender. Now, something that's very important that has come up in the last few weeks that is going to be on this form, and it's the highlighted language in the box. And I didn't even talk about this at the legal update that I did a little while ago, because it was conceptually, it was not kind of, we had not worked that out, but it says that if in the seller's response to the objection, the seller agrees to cure all of buyer's objections in the manner requested by the buyer, then per the NMAR purchase agreement, residential resale, NMAR form 2104, the parties are obligated to execute a resolution addendum reflecting that agreement. Now, this is not different from the way that we have handled the purchase agreement before. We had that same language for ORWs. We said that in the event that the buyer asks for things to be done and the seller says, fine, I'll do absolutely everything that you've asked to be done, you have an agreement on the ORW, correct? Right? That's the way the ORW works. And the reason that we added this language is because if you may recall, a number of years ago, we had an issue, because what was happening is that buyers were standing at a crossroads, making a decision as to whether or not to object to their inspections and things like that, or to terminate the contract. And they were opting to object instead of to terminate. Well, what was happening is that they were then trying to pull their objections off the table and terminate the contract before the seller even had an opportunity to respond. And because of that, we added language to the purchase agreement. It's currently in there right now, that in the event that the buyer has made their objection, so they've gone past their objection deadline and they decided to object opposed to terminate, then they must wait for the seller to respond. And if the seller gives them everything that they asked for, exactly how they asked for it, then of course you have resolution. And if you have resolution, at least to those issues, then the buyer cannot terminate based on those particular issues. So this tracks that same process, or that we've been currently using. We're saying to the buyer, you have to make an election by the objection deadline to terminate or to object. And if you decide not to terminate and you decide to object, then you have to allow the seller an opportunity to respond before you can terminate the contract. And if the seller gives you everything you want, then you are obligated to enter into a resolution addendum that reflects that agreement. So remember that that's the way it works. And that's part of the reason that we're telling them at this stage of the game during the objection phase that you want to talk to your lender before you even make these objections, because if the seller accepts them all just as you requested, then you're going to be obligated to enter into a resolution addendum, and a resolution addendum could impact your loan. Right? In the ways that we say here, it could be, the ability to get the loan, cause delays in the lender's processing and funding of the loan, cause the lender to require further inspections and or repairs. So since these objections could lead to that, we want you to be talking to your lender buyer when you're making these objections. So that's very important to remember. And then it goes on to talk about your buyer's right to inspections and objections. And again, this is nothing new. It reminds the buyer that if they object to an item on a document, survey, ILR, or video, they shall produce with the objections a copy of the entire document. And if they object to an item on an inspection report, then they're only going to submit the sections of the inspection report on which their objections are based. We changed this in the purchase agreement a number of years ago, and yet we still are having issues with buyers sending over the entire report. And I guess I should take a step back, because it really isn't the buyer sending the reports over. It's the buyer's broker sending the reports over. And that really is a problem, because as a buyer's broker, you are obligated to assist your client in conforming or following the terms of the contract. And the contract says, you're not going to send that whole report over. You're only going to send those sections of the report. If you're objecting, if you're terminating, you're not going to send anything. And then it goes on to say, unless the seller requests it in writing. And if the seller requests it in writing, then the buyer is obligated to provide it. It's really important that we kind of get on board with that. Again, even though it's been in there for a number of, I think, a couple of years now, at least, we are still not seeing that's not being complied with by the buyer side of the transaction. And I will say that there is a complaint pending before the Real Estate Commission right now on that very issue. A seller actually filed a complaint against a buyer's broker for sending the entire report over when the seller had not requested it. I don't know how that's going to play out at the Real Estate Commission. I think that the broker's response to that, or their defense, is the fact that they have an obligation to disclose all adverse material facts. But there's plenty of case law in New Mexico that makes it very clear that the recipient or the beneficiary of a particular right in a statute or a regulation has the right to waive that right. And essentially that's what the seller has done. Yes, you have a duty as a real estate broker to tell me everything bad that you know about my property. I'm telling you in the purchase agreement that I don't want that information. Unless I specifically requested, I don't want that information. And so the seller is very knowingly waiving a right to that information. And so we'll see how that plays out at the Real Estate Commission. I will also add, for those of you who haven't heard me tell this story 100 times, I find it interesting, and I'm sure it'll be a first for some of you. So Washington State has a similar provision in their purchase agreement that says that the buyer will not send the inspection report over to the seller unless requested. And they were having the same issue where the buyer brokers just kept sending the reports over, even though the seller wasn't requesting it. And so what they put in their purchase agreement is that in the event that the buyer or the buyer's broker sends the inspection report over without the seller requesting it, it constitutes a waiver of the buyer's inspection contingency. And I was so blown away by that I called and had a long conversation with my counterpart up in Washington and said, how in the world did you get that in there? And evidently their forms committee was experiencing, the people on the forms committee, the brokers were experiencing the same thing, where buyer brokers were not, respecting the contract and doing what was required by the contract, that they put that language in there. And I said, well, what came of that language? Well, initially there was a lot of buyer brokers writing earnest money checks, because what was happening is that the buyer would then want to terminate because they couldn't come to resolution on the objections. And the seller would say, I'm keeping your earnest money. You waived your right to object. You waived your right to your inspection contingency because you sent the entire report over. I'm keeping your earnest money. But again, because it wasn't the buyer who was sending the report over, it was the buyer's broker who had done it, not the buyer. The buyer, of course, was looking to their broker and saying, why did you, do this and put me in this position where I would lose my earnest money if I wanted to terminate? And those buyer brokers were writing checks. Now, it only happened, probably one time for each buyer broker who did that, and then they weren't doing it anymore. So it really did stop the practice. I will also say that the forms committee has decided that that's the direction they want to go in, that they actually want to add that language to our purchase agreement. That has not gone to the executive committee, who ultimately has to decide whether or not they agree with that. In the event that they do agree with it, then you would be seeing it rolling out in January. And I will be talking a lot about it over the next couple of months to try to get the word out if it gets past the EC. But again, it's an attempt to try to stop this practice. Even though the language says what it says, it's not being followed, and that's a problem. The highlighted language under B I wanted to bring to your attention because this comes up quite frequently, and we've added language to address it specifically in the purchase agreement, which is also now here in this notice of objection. And it says that upon seller's written request for the report, the buyer shall provide said inspection report or video within 3 days of seller's request, and buyer shall provide said inspection report to seller without payment or other compensation. So we're still getting that pushback where the seller requests the entire report and the buyer says, only if you pay me for it. Nothing in our contract requires the seller to pay for the report. So we're making it very clear, even though I think it's already clear, we're making it even more clear here in the purchase agreement that if it's requested, there is a time frame for providing it. 3 days of seller's request, it has to be provided, and it's going to be provided without payment or compensation to the buyer. And what happens if the buyer doesn't do that within that 3-day period? Well, that's a 2-day notice to cure. So that's something that's not new in our contract either. It's been in there for a while, and a lot of people don't realize it's in there. If you have a deadline for performance in our contract and somebody doesn't perform, then the requirement under the contract, the 2104, is to send out a 2-day notice to cure. And it gives that party, that non-performing party, 2 days to do whatever it is they were supposed to do, produce a document, or, in this case, produce the inspection report, whatever it is they are required to do. I hope that you guys have familiarized yourself with the 2-day notice to cure in the contract, because you need to know when it applies. I wrote an article about the deadline default a number of probably a couple of years ago or 18 months ago or more. And, it's important to understand when it comes into play, when there is a default and when there is a deadline. And so we have deadlines such as, the inspection objection deadline. But when that objection deadline isn't met, the buyer doesn't actually make their objections, it doesn't constitute a default. It means that the buyers waived their inspection contingency, right? They lost the right to object because they didn't do so timely. So you have to understand how that deadline default works and when it comes into play. But remember that it's there, and that's the reaction. If somebody doesn't do something the way they're supposed to, when they're supposed to, if it is required by the contract, there's no requirement that you make objections, right? But if it is required by the contract, then the response to that is a 2-day notice to cure. And when we put that notice in there, a lot of people said, I don't know why you give them a second bite at the apple. They've already defaulted by not performing. Why do you let them, give them that second bite? Well, first of all, it's very common to have a cure period in a purchase agreement. It was kind of odd that ours didn't have any. Our commercial agreement has always had a 5-day cure period in it. But we had nothing in the residential. But it not only benefits the party who has breached, because again, they have 2 more days to fix whatever it is they did, if it's fixable. But it also helps the non-breaching party, because in the event that they want to, for example, a seller wants to move on because a buyer didn't do something they were supposed to do, or a buyer wants to move on because a seller didn't do something they were supposed to do. The fact that they breached the contract, were given an opportunity to cure that breach, and then failed to cure it within the time frame provided, really does solidify the non-breaching party's position. So if they want to move on, or they want to sue for damages, or whatever it is they want to do in response to that default or that breach, they have put themselves in a much better position to pursue that, because they have given that notice to cure. C is also out of our contract, but again, this is not new language. Once the buyer makes the objections, the buyer may not withdraw their objections for the purpose of terminating the agreement until seller has responded, and may only terminate after seller's response if the seller does not agree to cure all of buyer's objections in the manner requested by buyer. So again, it's the same language that you currently see in our contract, so that's not new. And then, sorry guys. All of a sudden arrows just stop working, and I can't explain that. So I want to just briefly talk about, this is the second page of it, and you'll see at the top, because there's not a ton of room here at the bottom, obviously, for the buyer's objections, and you may very well need more space. So we've created an Exhibit A that will provide you with more space. So there's a box that says, if checked, additional space is required in Exhibit A, which is our new NMAR form 2200, is attached. And we'll look at Exhibit A in just a second, but it's basically just, a couple of blank pages that will allow you to just, write whatever you want to write as far as objections are concerned. And it also can be used with the response forms, the resolution addendum, and other forms in the library as well. So we'll look at that in a second. And then there's a warning, attention buyer and seller. If the parties are unable to reach a resolution deadline, and this is a new concept, okay? So as you know, currently the way the contract works is if they can't reach a resolution by the resolution deadline, then the contract will automatically terminate. That's the way our contract reads, and the earnest money will go back to the buyer. But we have built in an additional 2-day period for the buyer to withdraw their objections if no resolution is reached by the resolution deadline. And that's what this paragraph tells them. So in the event that you hit the resolution deadline, there's there's been no resolution, the parties can't come to an agreement on how to resolve the buyer's objections, then the buyer will have 2 days to pull their objections off the table. And that's the buyer's new withdrawal of objections form. Now, we've always had that concept in our contract. It specifically says that the buyer can withdraw their objections anytime up to the resolution deadline if no resolution looks like it's coming forward. But it was always kind of a timing thing. It was always kind of the parties playing chicken, so to speak. You know, the buyer didn't want to withdraw their objections too soon because they wanted to see if the seller was going to do anything. But at the same time, if they waited too long, then the resolution deadline would hit and the contract would automatically terminate. So now they don't have to do that. They don't have to worry, oh, the resolution deadline is hit and I missed my opportunity to withdraw. They will have 2 days following the resolution deadline to withdraw their objections. And what they're withdrawing is all unresolved objections. So I think we've actually, the title of 5144, that new buyer's withdrawal of objections, is buyer's withdrawal of all unresolved objections. Because again, that's the only way you're going to keep this contract from terminating, is to pull every unresolved objection off of the table. And if they do that, then there's nothing to resolve, right? You don't have, there's nothing to resolve because everything has already been resolved and all those unresolved issues are now no longer on the table. So there's nothing more to resolve as far as those are concerned. In the event that the buyer does not pull off all the unresolved objections within 2 days of the resolution deadline, then the contract will terminate and the earnest money will go back to the buyer. But if they do get all their unresolved objections off the table, then the contract will continue. You'll see that there is space for the buyer to sign, but only the buyer to sign. There's no place on here for the seller to sign. And then it goes on to talk about the seller's options in response to this objection form. So if seller agrees to cure all of buyer's objections in the notice, the parties shall complete and sign a resolution addendum to the purchase agreement incorporating all of buyer's objections and seller's agreement to cure those objections. That's the new form 5143. And if seller does not agree to cure all of the buyer's objections in this notice, the seller shall complete a response to the objections 5142, in which the seller states the objections, if any, that seller is willing to cure. So those are the options. If they're going to do everything, the parties go ahead and enter into a resolution addendum. If they're not going to do everything, then the seller will respond to the buyer and will tell them exactly what they are willing to do. And then at the bottom of the form, you see a buyer's withdrawal of objections. Now we have a standalone form, which is buyer's withdrawal of all unresolved objections. And then we have this section at the bottom of the buyer's withdrawal of these specific objections. So if for any reason the buyer wants to withdraw just these objections, they can use this form to do so. If they were going to withdraw all of their unresolved objections, again, to keep the contract from terminating, then that's another form that they can use. So they could do it either way. If this was the last of the unresolved objections right here, this objection form, whatever number it is, you could use this form to withdraw those objections. Again, alternatively, you could use the notice of withdrawal of unresolved objections, which pulls every unresolved objection off the form. Off the table. And I will add that it is important for the buyer to be withdrawing their objections opposed to the buyer's broker. We constantly get into this. I've talked about it a million times. Brokers are not working as agents for the most part. They're working as transaction brokers. And the good news of being a transaction broker is that you have far less liability associated with that relationship. You owe broker duties, you don't owe fiduciary duties, far less liability. However, the flip side of that, or the downside of that, is you also don't have the kind of authority that an agent has. So be careful in withdrawing buyer's objections. Make sure that the buyer is getting those. You certainly don't want as a broker, as a buyer's broker, to be withdrawing objections without something signed by your buyer, because if that's not their position, if that's not what they want to do, once you withdraw all those unresolved objections, then they're going to closing. If that's not what they want to do, you want to make sure they're the ones who have initiated that withdrawal and not you as the broker. So Exhibit A looks something like this. Nicole has cleaned this up and made it look a lot prettier. And but I wanted to bring it up because I realized this morning that the Exhibit A, well, I realized this when the forms came out, was not the correct version of this form. This Exhibit A is just going to say that it's an exhibit. It relates to the purchase agreement dated on such a date with the buyer and the seller, just identifying what purchase agreement it relates to. It's not an amendment to the purchase agreement. It's just simply related to the purchase agreement. And then it goes on to say it's an exhibit 2, and there are check boxes Buyer's notice of objection number such and such dated, because like I said, you could have different objections numbered. And so you're going to put the objection number and the date that it was submitted. Seller's response to the notice of objection, buyer's response to the notice of objection, resolution addendum. So you're going to be able to identify exactly what it is you're using this exhibit to. And actually under resolution addendum, we put another box that says other, because if you wanted to use exhibit A for, some other purpose with some other form in the NMAR forms library, there'll be a checkbox other, a line. You can write it on that line, and then you can use it as an exhibit for anything that you need more space for writing, that you may have be working with in the library. So that's, generally speaking, that's kind of what it looks like, which is different than the form that was released. Like I said, those will be updated and re-released, and the new exhibit A has gone to the vendors. We then have the response form. So like I said, if the buyer sends over objections and the seller agrees to everything, we're jumping right to the resolution addendum. And who should create that? Well, normally in that scenario, the seller would probably create it, right? Because they've received the objections, they agree to everything. They'll put together the resolution addendum with the buyer's objections and their agreement to cure all of the objections, just as the buyer had requested, and they'll execute it and they'll send it over to the other side for signature. But in the event that the seller isn't agreeing to do everything and they want to continue to negotiate these objections, then they are going to send over their response. So it's response number, whatever number it is, to notice of objection number. And the reason that we say response number is because this response form can be used by the buyer too. So in the event that the seller sends a response over and the buyer says, no, that's still not good enough, then the buyer will go to the library, pick out their own response form, and they will number it accordingly. So response number 2 to notice of objection, say number 1, and they will send over their response. So that's why you see response number is blank and notice of objection number is blank, because those will be filled in by the brokers as they are going through this process. Again, we're telling them that this is not an agreement, because it's only going to be signed by one party or the other. It's either going to be signed by the seller if it's their initial response, or it's going to be signed by the buyer if the buyer is responding to the seller's response. It's only going to be signed by one party, not both of them. And then we tell them what you can do in response to this notice. So if seller or buyer, as applicable, agrees to response in this notice, then the parties are going to create a resolution addendum. So again, if the seller sends their response over, buyer says, yeah, I'm good with that, the buyer is going to go ahead and create a resolution addendum, and they're going to execute it and send it over for signature by the seller. If seller or buyer, as applicable, do not agree, then they're going to create their own response form, a brand new number 5142 response form that they're going to send back over to the seller. And that's the process. They're going to go back and forth with these response forms until they come to an agreement. And once again, we tell them about consulting with the lender, because when you enter into that final resolution addendum, it could impact the loan if the buyer's getting a loan. So be sure to consult with the lender before you enter into that resolution addendum, after you get through with these responses going back and forth. And we tell them again on the resolution addendum, as you will see in just a moment. You'll notice on the response, again, to the notice of objections, again, only one party or the other will be signing, never both. Also, there's a reference to the exhibit. So again, if you need more space for your responses, then you will be able to use the exhibit A that we just talked about to indicate, what other information you want to share. And there is a little space there. So the seller's responses may include a willingness to fix things, something is requested by the buyer, a seller concession, a price modification, anything can be set forth in here. I think maybe what we're going to be seeing as a result of this, realistically, if people are concerned, borrowers are concerned, they're talking with their lenders, are concerned about writing, putting down repairs that ultimately show up on the resolution addendum that, will impact the lender's willingness to close the deal when on time. They may want to see repairs done before the closing, these kind of things. Then, I think what we're going to end up seeing realistically is more seller concessions and price reductions to address some of these repair issues, opposed to the repair issues. So this is the response form, again, initially used by the seller, but you see at the top, seller or buyer's response to notice of objections or response is applicable, again, because the buyer could be responding to the seller, and then the seller could be responding back to the buyer. And every time that happens, the parties are going to the library and pulling a new response form. So this brings us to the, as I say, the star of the show, the resolution addendum, which is ultimately the addendum to, or the amendment addendum to the purchase agreement. It's the form that changes the purchase agreement, whether again, it'd be repairs, price modifications, or seller concessions. So on this form, the very first at the top again, okay, they can't be told that they weren't warned, that they need to talk to their lender before entering into the resolution addendum, because we tell them at every turn. So the box at the top, of course, says consult with the lender again, because it could have an impact on the loan. So before entering into this, please consult with the lender. And going back to the objections, remember, because that objections could automatically flow into this resolution addendum if the seller agrees to do everything the buyer asked them to do, then they need to talk to their lender before they even make those initial objections. And we talked about that on the objection form. So this is the resolution addendum. I want to point out a couple of things. It says that seller agrees to cure buyer's objections as follows: repair, replace. So the seller agrees to all repairs and replacements listed below. And we have this new repair completion deadline that is set forth in the purchase agreement. So all repairs should be completed by an appropriately licensed professional. And we say appropriately licensed because if you don't have to have a license to do what it is that they are doing, then you don't have to have a license. So it's only obviously requires a license if what they're doing requires a license. I know that sounds rather obvious, but that's why we say appropriately licensed professional. If it's a handyman job and a handyman is perfectly not just capable of doing it, but allowed to do it by law, then of course a handyman can do it. But in the event that it requires a contractor's license to do whatever it is that the seller has agreed to do, then the seller is agreeing that they're going to use someone who is licensed as a contractor. It also goes on to say, and that provision is new. I know a lot of brokers used to add that, but it's new to our purchase agreement, and it is in our purchase agreement now. Also, this is new. Copies of all repair invoices shall be provided to buyer on or before the pre-closing walkthrough and shall include vendor contact information and license number. And really, you should say if license number if appropriate, because again, if it doesn't require, if whatever it was being done doesn't require them to have a contractor's license and it's just a handyman, he might not have it. Now, I will say that handymen are supposed to be licensed through the state. They actually, there is I should say, an application process or kind of alerting the contractors division to the fact that they are a handyman, and there is a whole process for that built into the law. There's also restrictions on what handymen can do and how much money that they can make doing it. So that all comes into play as well. But this requirement that these invoices are going to be provided and contact information is new. Like I said, I know a lot of brokers used to write that in to the ORW, but now it's actually in the purchase agreement. And it's also here in the resolution addendum. And then it goes on to say that if the sellers agree to repair or replace items in a prior addenda to the purchase agreement, then unless otherwise noted below, items to be repaired or replaced in that prior addendum shall be in addition to the items that the sellers agreed to repair or replace in this addendum. Now, this is very, very important. Okay, because this is saying that if you have, you have an objection to something, let's say a seller disclosure, and you guys went through the response process and they came up with a resolution addendum on that issue in the seller disclosure, and in that the seller agreed to replace something or repair something, then unless this box is checked, then that will be in addition to whatever it is that the seller has agreed to do right here. All right. If the box is checked, it says, if checked, the seller will not repair or replace items addressed in previous addendum to the purchase agreement. Seller shall only repair or replace the items noted below. Okay, so this is very important for everybody to understand this, because you don't want the parties to have negotiated something earlier and have that be taken away because you've checked this box, when the buyer thinks they're going to get both. They're going to get both the repair or the replacement that they agreed to do from the seller's disclosure, and they're going to get the repair and replacement that the seller agreed to do based on inspections. Now this box has been checked and you've just taken that away. So you have to understand how the form works, that, because we have to say in this, resolution addendum, the way usually addenda work in contracts is that, you're looking at the most current form, and or the most current last executed addenda. And if that form supersedes other prior addenda, then it means that those prior addenda do not have any relevance anymore. It's only the final one. So that's what we're establishing here. If the box is not checked, then the seller is going to repair or replace everything they've already agreed to do, plus whatever they're agreeing to do in here. And if the box is checked, then this is all they're doing. That's it. That's all they're doing. And you'll see on the second page that we have similar language. So this deals with repair replacement on the first page. And then on the second page of the agreement, we have price modifications and seller credits. So, and again, we have Exhibit A. So if you need more space, you check the box and you use the Exhibit A. And then we go into price modifications, which is simple enough. And you've seen this language before. We're just reducing the price as a result. And then, or increasing, but more likely reducing. And then paragraph C deals with seller credits. And again, this is different than the way that we were dealing with it in our current price mod form. So again, it's very important that you be familiar with this, because again, it says if the seller has agreed to provide a seller credit to the buyer in a prior addendum to the purchase agreement, then unless otherwise noted below, then those seller credits shall be in addition to the seller credits in this addendum. So if the offer came over and the buyer had asked for a seller concession of some sort, and then you subsequently enter into this addendum as a result of negotiations that came out of, inspections, then that seller credit in the original addendum that the seller agreed to and this seller credit are going to be combined, right? They're going to be in addition to, they're going to be added up. That's going to be the seller credit. But if the box is checked, the seller will not provide seller credits included on previous addendum to the purchase agreement. Seller shall only provide seller credits noted in this paragraph. So again, very important, right? It's very important that you stay on top of that and understand that if the intent of the seller says, I already agreed to give them a seller credit when they made their offer. I'm not going to give them an additional 5. I will give them a total of, 6 or 7 or whatever it is, but that's going to be everything I'm willing to give. Well, in that case, they will check the box, because that box says that this total right here, whatever they fill in this paragraph C, is the total amount that the seller is willing to give. And any other addenda that has been created that has a seller credit in it will go away, right? It won't mean anything anymore. So it's very important to understand how the language in here, because it'll make the difference for the parties, of course. And then the paragraph 2 is the title commitment revision fees. So if there are revision fees as a result of, seller credits or concessions or whatever the case may be, who's going to pay for that? That's already in our price modification. You've seen this before. And if there are any conflict between provisions of the purchase agreement and this addendum, the provisions of this addendum are going to control. So you'll see here at the bottom, everybody is signing on this, which makes it an addendum to the purchase agreement, which means it must go to the lender. So this is ultimately the document, whether we're doing repairs, seller concessions, or seller credits, that are going to make its way over to the lender in the event that the parties have fully executed this document. And again, I will remind you that in the event you have somebody, whether it be the borrower, whether it be the quote unquote lender, telling you we don't need to send this over. I'm telling you, you do have to send it over. And if it doesn't make any difference, then what's the harm? And if it does make a difference, then keeping it from the underwriter is a problem. It is against the law. There's no way around that. There's absolutely no way around that. So please make sure that these are getting to the lender. Unfortunately, like I said, too much was being negotiated on that ORW that wasn't getting to the lender. I had one broker call me one day, and they had negotiated, there was a loan, and they had negotiated $40,000 in an ROW that would go from the seller back to the buyer after closing. And I said, did that agreement make it over to the lender? And her response, and it was really quite innocent of her. She wasn't trying to do anything illegal, not at all. She's a wonderful broker. She said, if I send that over to the lender, then they may not make the loan. I said, well, that's mortgage fraud. So the QB jumped in, and I don't know if I can be proud of brokers. I sound like a parent, don't I? But I was proud of them, because ultimately they went to the buyer and said it has to go to the lender. The buyer didn't want to send it to the lender, and the broker said, well, then we're stepping away from this deal. We're not going to be involved in doing this if it doesn't go to the lender. And then magically the buyer found a big bag of cash somewhere and decided to pay cash for the property opposed to getting a loan. So it all worked out in the end, but the brokers had to step up and realize that what was happening was not okay. So again, that's the reason we moved in this direction with these forms. One of the things that we have done, well, let's go through this So when I did this flow chart for the update, the live update, it didn't look anything like this. People kept, kind of reaching out to me and saying, well, could you add this? Could you do this? Could you help, could you kind of expand on this flow chart a little bit? And this is what you see before you. I'm not sure if it's a good thing or a bad thing, but you'll see it. We start with the buyer makes the objections in the form 5141. That's step one, always step one. If the seller agrees to everything, then the parties sign a resolution addendum. So the seller gets the objections. They want to do exactly what the buyer has asked them to do and the way they want to do it. Then the seller goes ahead and executes that resolution addendum, and everybody signs off on it. You'll see an arrow at the top from the if the seller agrees to everything to this note over on the side that says, if the seller agrees to cure all the buyer's objections just as requested by the buyer, then the parties are obligated per the purchase agreement to execute the resolution addendum. Remember, it's not a choice, it's an obligation. They've already signed up for that when they sign the purchase agreement if the seller gives the buyer everything. So that's important to remember. And then in the event the seller doesn't want to give them everything, the buyer can terminate the purchase agreement. That's also already in there and already has been in there. So if the buyer makes their objections, they have to wait for the seller to respond. But if the seller comes back and doesn't give them everything they've asked for, the ball's in the buyer's court to terminate the contract at that point. They do have to wait for the seller to respond. And if the seller gives them everything, they have to enter into a resolution addendum. But if the seller doesn't give them everything, then the buyer can respond. And it's very important to understand that that's the way the contract works, because so often, the seller will go back with some alternatives and the buyer will terminate. And then the seller wants to be doing this backpedaling, right? No, wait a second. I'm happy to do the things that, they asked me to do. I just, was kind of, testing the waters and seeing what I could get away with not doing. So the seller needs to be aware of the fact that if they don't give the buyer everything that they've asked for in the way they asked for it, it does put the ball in the buyer's court to terminate at that point. So in the event that the seller has not agreed to do everything, if you go down here on the left, you see that the seller has an opportunity to respond in the NMAR form 4152. And then it goes on to say you use different response forms each time. You number all the forms sequentially. So if the seller responds, that's response number 1, and the buyer responds, that's response number 2, and then the seller responds, that's response number 3. So you're numbering them sequentially. And then when the seller responds, if the buyer agrees to everything in the seller's response, again, you're going to execute this resolution addendum and everybody's going to sign off on it. Or if the seller has not agreed to cure all of buyer's objections as requested by the buyer, again, the buyer has the option to terminate if that's what the buyer wants to do. And then alternatively, if the buyer doesn't want to terminate, but they haven't come to an agreement yet, then the parties can go back and forth with these response forms, right? As many times as they need to do it. You guys were always complaining about the ORW not having enough opportunity for going back and forth, right? And what happens if we want to continue to negotiate and we can't resolve this within 3 or 4 pages that we have to do so? Well, that is taken care of now because everybody's grabbing a different response form every time, and those can go back and forth indefinitely. So if the parties do not reach an agreement by the resolution deadline, if you take it over there to the right-hand side of the screen, you see then the buyer has 2 days to withdraw all the unresolved objections, form 5144. And if buyer does not withdraw all unresolved objections within 2 days of resolution, then the purchase agreement will terminate, earnest money is returned to buyer. And then on the bottom part on the left, it says if parties reach an agreement by the resolution deadline, then you take it all the way back up to the top of again, and the parties sign a resolution addendum and you move on with the contract. So I have really expanded on this flow chart. I hope that you find it helpful, and they are going to be posting it on the NMAR website so that you have a copy of this. We have a new notice of withdrawal of buyer's objections, and it's actually all unresolved objections. You can see the title here, and this is form 5144, and I've referenced it several times here. And there's a warning box, of course, there's always a warning box, right? When I talked about this before, we initially thought what we would do is be able to withdraw certain objections. But again, you can do that on a particular form. You can send over an objection form and withdraw any given objection that you want to withdraw. And ultimately what this form does is pull off all unresolved objections for the purpose of keeping the purchase agreement from terminating. So we reworked this form a little bit so you don't have to identify specific objections that are being withdrawn, because again, the only reason you would use this is because you don't want the contract to terminate. You're trying to pull off all unresolved objections. So we don't need to enumerate the specific objections. If for some reason you want to withdraw a specific objection, then use the withdrawal of objection at the bottom of the objection form that we went over. This form is for all unresolved objections, again, so that the contract, it doesn't just terminate. So unresolved objections or buyer objections submitted to seller as to which buyer and seller have not reached a written agreement specifying how those buyer objections will be resolved. Written agreement. Remember, written agreement is how we define resolution. If the parties are unable to reach a resolution from terminating, if they don't do that, then it is going to terminate, and earnest money is going back to the buyer. In withdrawing the above reference notice of objections, and actually it should say in withdrawing all unresolved objections, buyer understands that seller is not obligated to repair or otherwise remedy those buyer objections for which resolution has not been reached. So in the event that they have reached resolution, because we go on to say that sellers obligated to repair or otherwise remedy objections for which resolution has been reached, such as repairs or remedies to be conducted as agreed upon between the parties in another resolution addendum. So in other words, if you negotiated a seller disclosure and you came up with a resolution addendum and where we've agreed how the parties are going to resolve that particular issue from that seller disclosure, the seller is still obligated to do that because that's resolution. They've already reached resolution, right? It's just the unresolved objections that are being pulled off the table here. And those things are things, the seller is not going to be obligated to do because there was never resolution reached on it. But they still have to do what they have agreed to do on prior resolution addendum. So this is our withdrawal of objections. And like I said, this would be used for all unresolved objections. And that third bullet down there, I'm going to change that to say withdrawing all unresolved objections. Buyer understands seller is not obligated to repair or remedy those buyer objections for which resolution has not been reached. So this is the form you would use for that. Again, the concept's not new. You had been addressing that in our contract for some time. We just didn't have a form for it. We also have a new waiver of inspections and observations contingency. So as you guys recall, you see number one, this is a standalone form 5140. It's a new form in our purchase agreement as it stands today in our library. What you see for purposes of waiving inspections is this number one, buyer waives all inspections is required by law, unless required by law, all of inspections unless required by lender. Buyer waives the following inspections. And that's all we have in our purchase agreement. The market's changing already. It's amazing how fast that can happen, isn't it? It's just incredible, but it's changing. But, what we were going through for, about 18 months, 2 years before it started changing as of late was buyers doing anything they could do in order to get a property, waiving appraisals and waiving contingencies and paying over list price and doing all sorts of crazy stuff, right? Escalation clauses and it was kind of a crazy market there for a while. And what's come of that, unfortunately, is a lot of buyer remorse. We're already hearing about buyers who purchased in that crazy market being unhappy with the fact that they waived inspections, they waived appraisal, they paid over list price. We're already seeing that. And of course, who do they blame? They don't take responsibility themselves for those decisions. Instead, they want to say that their buyer's broker is the one that, twisted their arm and talked them into waiving everything in order to get the house. And we're already seeing that's already happening. And so we decided that it was important, even though the market is changing again, it will change again because that's just the way it is. It's very cyclical. We decided that we needed to really hit home the point of waiving your inspections and your observation contingency. It's a big deal, and we needed them to really be aware of what they were doing. And so we pushed them off of the purchase agreement onto this standalone form. They still have the same options under number one that they had in the purchase agreement, but number two goes on to tell them exactly what the effect of this waiver is. So they're acknowledging and disclaiming. They're saying that the buyer will not have the opportunity. I understand I will not have the opportunity to conduct any of the waived inspections in paragraph 1, and I will not have the right to object or to terminate the purchase agreement based on buyer's observations of the property or issues or defects that may have been revealed by those buyers' inspection. We then go on to say that notwithstanding the foregoing, the buyer retains the right to make objections in accordance with the purchase agreement to seller provided documents or disclosures. So just because you waive inspections doesn't mean you can't, unless you've also waived your right to object to the seller disclosure form or other forms that or documents that have been provided. You're not waiving the right to object as a buyer to those documents, only to the inspections and observations. Then it goes on to say if the buyer fails to close on the property due to buyer's own observations or some defect or issue that would have been revealed by buyer's inspections, which was not otherwise revealed by the document or disclosure provided by seller, then the buyer may be in default. And it is buyer's decision to waive the inspection and observation contingency as to the inspections indicated above. It's not based on any representation made by the seller, listing broker, or buyer's broker, and for good and valuable consideration, which is required for a contract. The sufficiency of which is hereby acknowledged, the buyer does forever hold harmless the seller, brokers, and brokerages with respect to any damages the buyer may suffer as a result of this waiver. Now, will this protect the seller for not disclosing adverse material facts? No, it will not. Or brokers for that matter. No, it will not, right? Because that obligation exists. Even if they're waiving their inspection contingency, you still have to disclose adverse material facts. But this is saying that in the event that the seller is unaware of adverse material facts, brokers unaware of adverse material facts, but things would have come out if the buyer had done their inspections. Well, the buyer has waived those inspections. They know what they're doing. They've done it knowingly, and they're not going to have recourse against the seller or the brokers. Does that keep a buyer from suing? No, it's not going to keep a buyer from suing. Is it going to provide a defense to the seller and to the brokers involved? Yes, that's what it'll do. You know, to the extent that it can provide a defense, that's what it's doing. It's not going to keep somebody from suing. Unfortunately, anybody can sue for anything. But again, important that we push them off if they're waiving inspections. Maybe not so much right now in the market the way it's going. It's trending right now, but I'm sure we'll be back in another crazy market, and this will be very important. Those are kind of all of the forms that are associated with the new ORR process, the waiver form, the objection form, the response form, the resolution form, and that's the process. So like I said, all the forms are with the lender right now, the vendors right now. And we are really hoping that all of those, you know, will be live in the library and sometime in the next week or so. Form 1106. Which is our listing agreement, exclusive right to sell listing agreement. 1206, which is our buyer broker agreement. Also cover page 2 of our purchase agreement, which we'll look at here in just a minute, deals with consent for dual representation. So standard of practice says that realtors may represent the seller and landlord and buyer and tenant in the same transaction only after full disclosure to and with informed consent of both. And though cover page 2 always disclosed whether or not the buyer and the seller's broker were one in the same, it really didn't take that extra step towards consent. Or maybe it didn't do it as well as we feel like it should have been doing it. And so that's the change that we've made. And we've made that same, we've added that same language to 1106 and 1206. So in 1106, by the initials to the paragraph, seller consists of broker also representing a buyer, tenant in the purchase or lease as applicable of the seller's property, and seller understands that they're not obligated to consent to this dual representation. And if seller does not consent to this dual representation and broker is approached by an unrepresented buyer, then the listing broker will advise the buyer to procure their own buyer's broker. And then there's a place for seller's initials. And I know we're not crazy about seller's initials in the middle of a form, but this is relatively important. So we really felt like that was necessary. You'll see this in 1106 coming up, and it's very important for brokers, obviously, to have a real conversation with their sellers about this dual consent provision and allow the sellers to make, because consent means nothing if it's not informed consent. So, you know, informed consent means you understand what your rights are and you are voluntarily waiving them. And without informed consent, you know, it doesn't, and full disclosure, as you can see here from standard of practice 1-5, the consent means nothing. So please take a moment to have those conversations with your sellers when you hit that paragraph. Well, there's lots of paragraphs you have to talk to them about, but this is a very important one as well. So let's talk about the changes to the purchase agreement, some of which came as a result of this ORR process and some that were just, you know, necessary for other reasons. So cover page 2, as I said before, the in-house transaction. So again, as required by the Code of Ethics, informed consent for the broker to represent both buyer and seller in the transaction. So a lot of people are not working with buyer broker agreements. So the very first time that the buyer is going to have an opportunity to consent to this dual representation is in the purchase agreement on cover page 2. So that's where the brokers, the buyer's broker is doing so. The listing, the seller has already done so in the listing agreement, right? But the buyer needs to have an opportunity to do that as well. And if you're not using a buyer broker agreement, then this will be the first opportunity to do that. So that language was added to cover page 2. The earnest money paragraph no longer lists a title company. Instead, it references to the title company to paragraph 13 for the name of the title company. So we no longer are putting the title company in the earnest money paragraph. Instead, we're putting it in the section regarding title. Paragraph 6, the viewing in the property. This box was moved to the beginning of this paragraph and the options were expanded. So the viewing of the property, as you recall, solicits information about whether or not the buyer has been actually to the property, physically come to the property. We also have an option for whether or not they've viewed it remotely with their broker, meaning that the broker's at the property and using, FaceTime or something along those lines to walk them through the property in that manner, or whether or not the buyer has just simply seen pictures on the internet and has not actually gotten to view the property remotely or in person. So the new box has been expanded a little bit and moved to the top of that paragraph. Personal property has been arranged in alphabetical order. If you're looking for something, then remember now that it's in alphabetical order. The cash or loan or seller financing. As you recall, last year, I guess it was probably last year that we changed that whole section to say that the buyer cannot change the type of loan they're getting, their lender, the way that they are financing the property, unless the seller approves of that change, and the seller has to approve that change. But now we've added language that says that the seller's approval should not be unreasonably withheld. So, if you have a buyer who wants to change from a loan to cash and is able to provide proof of funds, there would be no reason why that seller shouldn't allow that to happen. So if they did, then that would be, unreasonable to withhold approval of that change. So whatever that change is, if there's going to be a change to the lender, but it's not going to have any impact on when the deal closes, then it probably is not reasonable for them to withhold that. They want to go FHA to conventional. Conventional is a little easier, so there's probably no reason to hold that approval. So just be having those conversations with your seller if you're faced with that question. Now, of course, if it is going to delay closing, or you're dealing with a different loan program that could end up, result in repairs being made, or different things, then the seller does have a right to say, I don't approve of that change. In which case, either the buyer sticks with their original lender and their original loan program as they had contracted to do, or the seller will have a right to terminate the contract. So, but that new language regarding seller's approval has been added. In the lender rejection letter 7B3, if the buyer fails to provide a written rejection letter from the lender as provided in this paragraph, buyer will not be given an opportunity to cure the failure. Now, remember that this particular paragraph says that in the event we have this, we have a financing contingency in our contract. The buyer said they need to get a loan. They can't close without a loan. And so normally in the event that the buyer doesn't get their loan in place, then it's a contingency that wasn't satisfied. They get their earnest money back. They get to go down the road. However, in our contract, in the event that the buyer doesn't provide a written rejection letter from the lender within so many days prior to closing, and our default is 3 days, you could be provided, you could say 1 day, you could say 2 days, you could say 10 days, right? It's a negotiable term, but we do have to have a default because too often that blank is left blank. And then the question becomes, well, how much time do they have to provide that written rejection letter? Well, I can't tell you if you don't fill something in there. And that's why we have the default period of 3 days. So if you guys don't fill anything in there differently, it's going to say 3 days. I'm sure buyer would like to put 1 day in there every single time. Seller may came back and want 3 days or 4 days or 5 days or some other number if it comes over with 1 day. But anyway, it's all negotiable. But the way our contract works is if the buyer doesn't provide that written rejection letter within that time frame, then the buyer doesn't get their earnest money back. The seller can't sue the buyer for additional damages because they did have that contingency in place, that financing contingency, but the buyer could still lose their earnest money. Very important, right? Very important for buyers. And so we have added to this paragraph the fact that, clarifying this is not an opportunity to cure. So you don't have to provide a written rejection letter. You're not required to do so. You are required to do so if you want your earnest money back, but you're not otherwise required to do so. But if you don't do it, buyer, you don't get a 2-day notice to cure. You don't get an opportunity to fix that. You didn't provide it, you're going to lose your earnest money. And the reason that we added that years and years ago was because we didn't want the sellers loading up their whole, U-Haul truck or, whatever it was, and driving out of the driveway before they found out that the buyer wasn't actually going to buy their house. So we figured, if you can't get it done, if you can't do this when you're supposed to do it, let us know so many days before closing. Otherwise, we'll get all packed up and be driving out of the driveway. And if that happens, then yeah, arguably the seller is entitled to some damages because the buyer didn't let them know ahead of time. Paragraph 9C, the appraisal deadline. There was a deadline added for the appraisal. So as you guys know, this appraisal deadline has come in and out and in and out of this contract. Well, this is the 3rd time now. And it's the deadline by which the buyer is obligated to tell their lender to order the appraisal. Now, the buyer can't control when the lender orders the appraisal, So all they can do is tell the lender. Of course, if it's a seller financing deal or a cash deal and the buyer has opted for an appraisal, then of course the buyer is directly ordering the appraisal and they have control of that. But otherwise, all they can do is tell the lender, and that's all that's required under this. So the reason that we added it every time, the reason why we added it is because buyers would sometimes drag their feet in ordering the appraisal until they got through the inspection negotiations, because they didn't want to incur the cost of an appraisal if they couldn't resolve the objections. So we added the appraisal deadline to kind of create a deadline so that it wouldn't delay closing. In the past, when we would put this in there, twice we put this in there, and twice we pulled it out. And the reason we've had to pull it out is because the seller was abusing it. So in the event that the buyer didn't order the appraisal exactly when they were supposed to order it, then the seller would look at that as an opportunity to terminate the contract. Oh, you didn't order the appraisal, that's a default. I get to terminate the contract and take this better backup offer that I have sitting over here, right? However, we didn't want that kind of abuse happening, because sometimes the failure to order the appraisal by the deadline was not even going to result in any delays in closing. So they missed it by a day. It wasn't going to result in a change in closing, but the seller was just taking that opportunity to terminate. They can't do that anymore because we have the 2-day notice to cure. So in response to a buyer, when a seller learns that the buyer has not ordered the appraisal by the deadline, their response to that is sending over a 2-day notice to cure and saying, hey, I know you haven't done this and you've got 2 days to do it, or yes, now I get to take this backup contract, that's so much better. But it gives them that 2-day notice to cure, so we don't have to worry about seller abuse, because the buyer will have a chance to make that right. So the next one that we changed is the appraisal value less the purchase price. This is paragraph 9D. It's very important to remember, because this came up consistently when people were waiving the appraisal contingency. They were referencing, it's now paragraph 9D, it used to be paragraph 9C, because we now added the appraisal deadline as the new paragraph 9C. But the paragraph 9D are buyer options in the event that the appraisal value is less than the purchase price. And we have emphasized now with this new language that they are buyer options. They have always been buyer options. They've never been seller options. But we saw consistently through that crazy 18-month market, or 2 years that we had of a crazy market, where the sellers and the parties were referencing back to paragraph 9C, at the time it was 9C, to say that if the appraisal came in low, then the seller had the rights afforded to them by paragraph 9C. But the seller has no rights really under 9C. I mean, the 9C has said, always has said, continues to say that if the appraisal comes in low, then the buyer has the option of buying at the purchase price. The parties have the option of renegotiating. Neither one of them have to renegotiate, but they have the option, or a buyer has the right to terminate. So all the seller has the right to do under paragraph 9C, the current one, and now the 9D, is to say, I'm not going to drop the purchase price. It doesn't give them the right not to sell for the purchase price. They have to sell for the purchase price if the buyer opts to buy for the purchase price. So we've added language that just says, these are buyer options, not seller options. If you're trying to create a seller's guarantee or a seller's floor, a price under which the seller is not obligated to sell, because if the appraisal comes in low a certain amount and the seller says, I don't want to sell if it comes in that low, then you're going to be using the appraisal waiver contingency form, or appraisal contingency waiver form. And options on that D and E create that scenario. D creates a specific guarantee that the seller will not have to sell for less than a dollar amount. And option E in that form says that if the appraisal comes in below a certain dollar amount, the parties are all going back to the drawing board. And if they can't come up with a new, they can't agree to a purchase price, then neither party has to perform. So if you're trying to create a seller's floor or a guarantee that the seller will not sell for less than a certain dollar amount, then you're using that appraisal contingency waiver form, and you're looking at options D and E. 10B is the funding date. Language was added to emphasize that if the buyer's lender does not fund by the funding date, it's a buyer default. This would trigger a 2-day notice to cure. If a buyer or seller doesn't close when they're supposed to close, or the buyer doesn't fund when they're supposed to fund, 2-day notice to cure is the response to that. Paragraph 14 was moved to the disclosure paragraph because the prorations paragraph had requirements for the seller to disclose certain documents. And so it made sense that it would be moved to the disclosure paragraph. Paragraph 17, which is the survey ILR paragraph, the last sentence regarding party who agreed to pay for the survey or ILR must do so even if the transaction doesn't close, was moved to the survival of obligations paragraph in paragraph 45. I'll talk about that in a minute and explain that more. Paragraph 18I, the miscellaneous disclosure prorations. Again, that's where prorations went. So the prorations paragraph, which was formerly paragraph 14, which included the disclosure of property specific fees, leases, memberships, etc., was moved here and retitled. So it now is called miscellaneous disclosure / prorations. It's in the disclosure paragraph with all the other disclosures, HOAs and PIDs and all that kind of stuff. 18J is the document deadline. Miscellaneous disclosures were added to that because, again, it was always this requirement that the seller disclose these things, but we didn't have any time frame for them to do it. So now we do have a provision in the grid for when they will be doing that. Paragraph 19, language added that addresses adverse material facts discovered after the initial adverse material facts disclosure is delivered. So we always had this, the sellers had this ongoing obligation to disclose newly discovered adverse material facts, something that they might have not known about, but which came to light after the parties were under contract. But we didn't have a provision for when do those have to be disclosed and what happens at that point. Now, I would argue the same thing happens at that point that happened in the beginning when those disclosures were made, that the buyer would have the right to terminate or to object, and then there would be negotiations that the buyer objected and there'd be resolution, right? But we didn't have any timeframes for that to happen. So we now do. It says it provides the buyer has 3 days from notification to object to this newly discovered facts. They have to be delivered, and then 3 days from that notification, the buyer can object or terminate, and then the parties have 6 days from the notification to resolve. So the buyer has the same rights they had before: termination, objection. If they object, they've got another few days to resolve the issue. So that's all set forth now in that section. In paragraph 19, also under the seller's duty to disclose, we know the adverse material facts do not include those facts exempt from disclosure under 47.13.2, and those are going to be added to the AMF disclosure. And we'll look at those. Actually, let's see, I think it's on the next page. Here we go. Yeah, these are those disclosures that we're referencing there. So you all remember this probably from one of your very first classes, real estate classes. We have very few laws that are so crystal clear about what has to be disclosed and what doesn't have to be disclosed when it comes to sellers and buyers. But we have a law directly on point that says that it is not required for the seller to disclose the fact that a property was the site of a natural death, homicide, suicide, assault, sexual assault, or any other crime punishable as a felony. It also goes on to say, and then also goes on to say that if it was owned or occupied by somebody who had HIV or AIDS. So those things are not required disclosure, and they do not allow for termination. So if a buyer finds out that that was the case, and then it wasn't disclosed because it doesn't have to be, it doesn't allow the buyer an out. Because that disclosure is not required. So that language was added that AMFs do not include those facts exempt from disclosure under 47.13.2, and those, what you just saw, will be added to the adverse material fact disclosure form that we'll talk about here too, because we have made some changes to that form. And then 21B, waiver of inspections. We've already talked about that. You can't do it in the form anymore. You got to move over to that addenda that we had talked about a minute ago. Payment of inspections, the last sentence regarding the party who agreed to pay for the inspection must do so even if the transaction isn't closed, was moved to the survival obligation paragraph, just like the survey was. That language in the survey paragraph, and we'll talk about that in a minute. That whole objection, response, resolution, termination process was changed, right? All changed to accommodate what we just went over as far as the ORR process was concerned. So you'll see a lot of changes in that 21H. Specifically, I wanted to again point out that language was added to H(i)(c), that upon written request from the seller, the buyer is obligated to provide the inspection report within 3 days of seller's request and to provide it without any compensation. We talked about that. In H(id), provides that written request from seller, buyer, if request from the seller, buyer is obligated to provide the inspection report within 3 days of seller's request. Oh, I already said that. I'm sorry, it's duplicative. Duplicating the prior slide. H(ie), buyer may not withdraw their objections for the purpose of terminating this agreement until sellers responded. We talked about that, and we've said that if in the seller's response, the seller agrees to cure all of the buyer's objections in the manner requested, the parties are obligated to execute a resolution addendum. And again, that language was in the objection form, and it's also in the purchase agreement. In the seller's response, H(2)A), The word may was changed to shall. So seller must do one of the following. So we say in there that the seller has certain options. We said options. And they are options. They have the option, but they have to do one of them, right? They either have to, reject all of buyer's requests for a cure, agree to all of buyer's requests for a cure, or propose an alternative cure. So in other words, the seller is not allowed to simply not respond. They have to do one of those three. We said may, but now we say shall. That actually came up before. There was a case in Santa Fe where an attorney argued that even when we said may, that those are the only options we give them. And so therefore they have to do one of them, right? So they shall do one of the following. Kind of follows along though, that, that supports the argument that attorney was making quite some time ago. But we really do want the seller to do something. They don't have to cure anything, but at least get back with the buyer and let them know what they want to do. In H little 3C, language is added if the parties don't reach a resolution, then that a 2-day period comes into play. You saw that in the forms as well that we went over. So the buyer does have the option to pull, not the right and the option to pull off all of those unresolved objections to keep the contract from terminating. The home warranty contract paragraph was changed just a little bit. The cost to be paid by the party indicated in the cost to be paid grid under miscellaneous fees. So the cost of this home warranty contract was often getting missed because it wasn't in the grid. It was in the home warranty contract paragraph. So we moved it to the grid, and then we referenced the grid in this paragraph so you know where to find that number. The assignment paragraph, we added language that in the event of assignment, the buyer shall remain liable under the purchase agreement. So remember that if there's nothing marked in the assignment paragraph, the contract's assignable. And if it's marked that it is assignable, then it's assignable. But we go on to say now, we added language that says that in the event that the buyer shall assign it, that this buyer shall remain liable under the purchase agreement. So even if the buyer has agreed, we call him the assignor in an assignment situation, has agreed with the person that they assigned it to, who we call the assignee, even if that buyer and the assignee have agreed that the buyer's off the hook, as far as the seller is concerned, the buyer will remain liable under the purchase agreement. So they're still on the hook, even if they assign the contract. And so the only way for that contract not to be assignable, of course, is for it to be marked not assignable. But I think most of the time it's probably coming over from buyers with the assignment will be allowed. And then it would require the seller to counter if they didn't want an assignment. Paragraph 45 is the survival of obligations paragraph. And so we had a survival of obligations paragraph saying that certain provisions of the contract survived closing. And these are boilerplate stuff, or what you guys might think of boilerplate language at the bottom, and who cares what it says? Well, you will care what it says if the buyer shows up at the property after closing and all those appliances that were supposed to stay are gone, right? And you want to say, I get those appliances. It said so in our purchase agreement. Hey, you closed. And under the law, there is what's called a doctrine of merger, which basically says that upon closing, you can lose a lot of the rights that you had in the purchase agreement. So what we're doing in the survival obligations paragraph is saying there are certain things that survive closing, right? And so if that should happen, we say the buyer still has recourse and can go after the seller for all the appliances that disappeared out of the house. We have also gone on now to say that there are certain provisions that survive termination. And we had a couple of those things in our purchase agreement already. We said if whoever agreed to pay for the survey still has to pay for the survey, even if the deal doesn't close. Whoever agreed to pay for the inspections still have to pay for the inspections, even if the deal doesn't close. But those were the only two provisions. But there are other provisions that we would like to survive closing and survive termination of the purchase agreement. And you know where this came up quite frequently is in regards to the request for the inspection report, because the parties would terminate and then the seller would come back and ask for the inspection report. And there is an argument to be made that, hey, you terminated the contract and that doesn't survive termination because it doesn't specifically say it does. So now the buyer is relieved from having to provide that report. So now we have a survival of terminations, and that is in there, by the way, along with some other paragraph that will survive termination. So buyers are still, or sellers are still required to pay for what they agreed to pay for. Just because it was moved out of that paragraph doesn't mean it's not so. It's now been moved into the survival obligations paragraph under the survival of in the event of termination, along with some other provisions. So you might want to take a look at those. For you property managers out there, we have updated this information sheet. It's the Service Assistant Animals Information Sheet 6111, I believe it is. And HUD issued some further guidance on in the fair housing context, they don't look at service animals any differently than they do emotional support animals or assistant animals. Of course, emotional support animals have no training or any of those along those lines, but they aren't treated differently in the context of housing. So if you're a property manager leasing to someone and you have a no pet policy and they say that they have a service animal or a therapy animal or emotional support animal, you have to allow them to have their animal. It's not considered a pet. You can't charge any additional rent. You can't charge any additional fees, pet fees, deposits, nothing along those lines. However, HUD has given us some additional guidance on what you can require as far as documentation is concerned to prove that this animal isn't a pet, that it is indeed an emotional support animal, because there was a lot of abuse in that area. People were pulling things off the internet, by doctors that they never even saw and saying that they need an emotional support animal. So now we have some further guidance that's been incorporated into this 6111. So make sure you take a look at that if you're doing property management. Recreational marijuana information sheet. So as you all know, recreational marijuana is legal in New Mexico, still illegal under federal law, but I will tell you that there's not a lot of enforcement going on at the federal level as far as marijuana is concerned. And there's a couple of bills making their way through the federal legislature that will legalize and take it off the controlled substance list. So, but currently in New Mexico, both recreational and medical marijuana are permitted. And so this information sheet just talks about it, what the federal law says, what the state law says. One of the main things that comes up from your perspective on this issue is disclosure. If a property has been used for the growth of marijuana, what are my disclosure requirements? So there are other states, as you all are probably aware, just ones to the north of us, that has had legalized recreational marijuana for quite some time. And as a result, they have determined this Colorado Inspection Services has determined a number of issues that they have identified in properties that have been used for the growth of marijuana on any kind of significant scale. And they have identified unsafe wiring, oversized fusing, damaged fixtures, holes for ventilations and electrical access, wood rot, rusted hollow columns, rusted gas burning appliances, mold from venting to interior attic or crawl space, deterioration of chimney mortar from venting to fireplace. They've identified issues with plumbing, because the plumbing facilities on the property are being used for sod and soil and different plant needed things that are needed to grow plants. Marijuana isn't like meth, so it's not seeping into the walls of these properties and making it dangerous from that perspective. It really comes down to how this property has been modified in some way to allow for the growing of these plants. I mean, it could be, if you're growing a whole bunch of orchids, you'd have to do the same, right? I mean, it's creating this greenhouse within a home in order to grow these plants. And so, of course, the question becomes whether or not you have to disclose that or not. And I'm constantly being asked that question, and we'll talk about that in just a second. But I wanted to just mention quickly civil forfeiture. And again, because the feds are not, they're just not paying a lot of attention to this at this point. A number of years ago they were coming in and they were seizing properties that were being used as grow houses under the civil forfeiture laws, which means that if you're renting to somebody who is growing, then the landlord's property would be seized as a result. We're not seeing that as much anymore. I'm not going to say it couldn't happen because it was happening for years, but I do know that there has been a significant decline in the number of civil forfeiture, asset forfeiture cases for properties being used for marijuana growth in the last few years. But the recreational marijuana sheet does talk about the disclosure requirements, and what it comes down to is, has there been modifications to the property to make it a grow house? That really is it. If you walk into a property and you see one little plant being grown on the windowsill, highly unlikely that they've modified anything to create a grow house as a result of that. I get asked, what's the magic number of plants? And there is a magic number of plants for purposes of how many you can grow under the law without having to have a license. But as far as disclosure is concerned, there's not a magic number. Again, it's about how has the property had to be modified, or has it had to be modified in order to allow for the growth of these plants? Have there been rewiring for lighting? Has there been You know, have they created a moisture environment that could breed mold and problems like that because they created this you know, ideal environment? So that becomes the question. And in the event that you see things that make you think that perhaps they have been, then of course you need to inquire. And if you think that perhaps it has been, even if you're being told it's not, then you're going to probably want to err on the side of disclosure. Not probably, you will. You want to err on the side of disclosure and say that you knew that, you know, there's a significant number of plants being, you know, grown in this property, and put the ball in the buyer's court to do whatever due diligence they feel they need to do to confirm that, you know, the wiring is fine and there's not mold issues and these kind of things. So the information sheet talks about these issues, and in the event that a seller has identified a property as a grow house, or a broker has identified it as a grow house, then of course you're going to want to share this information with your buyer. And if your seller is curious as well about what kind of, you know, issues can arise as a result, and things that you might have to disclose as a result, then of course you're going to want to provide it to them as well. We did, when we were working on this medical or in this recreational marijuana bill, I did create some language at one point to try to just, you know, have real clear disclosure requirements for brokers and sellers. Unfortunately, the bill had, or fortunately, had a lot of momentum, and the sponsor didn't want to introduce new language to it that might slow it down or kind of take it off track. And so ultimately, nothing specifically ended up in the act that addressed disclosure. So it's silent on that issue. So again, going back to how the property may have been modified. And this talks about adverse material facts. And as we all know, there's a case out there, and it's a case that really needs to be challenged by Rice. I hope at some point they do, because it was decided when there was agency relationships. And what it said was that New Mexico brokers do not have to disclose just what they know, but what they should have known. And like I said, I think perhaps it would be decided differently now than it was at the time. And interestingly enough, there's not a similar or equivalent seller case where it says the seller has to disclose things they knew or should have known. There's no such case like that. It says but there is a case directly for the broker to disclose what they knew or should have known. So as long as that's on the books, it's not just what you know, it's what you should have known. So again, if you walk into a property and you see a bunch of plants growing, you might not know that the property has been modified to accommodate that a bunch of those plants growing, but you may be charged with should have known if you see a bunch of plants growing, and you know that there are certain conditions that have to be created in order to allow those plants to grow. That could be an example of, hey, you should have known that there could be wiring problems. You should have known that there could have been moisture problems. You should have known. So from that perspective, again, remember that, you know, it's better to disclose than to not disclose and put the ball in the buyer's court. And those are conversations you can have with your seller, of course. Hey, I noticed there's a whole lot of growth going on here. I feel like I need to disclose this to the buyer for these reasons, and have that conversation so that they're aware of what your obligations are. There are, in the information sheet, we talk about leasing concerns because, you know, federal banking laws prohibit marijuana businesses from utilizing the banking system, since these business activities are still illegal at the federal level. And so there's some local banks and credit unions that openly accept accounts, but, you know, some businesses involved in the marijuana industry are compelled to operate on a cash-only basis. And of course, this can spur concerns about security, because other people who know this as well know there may be a lot of cash that they're dealing with in a location where they're selling, for example, marijuana. And so these are, you know, issues that a landlord, from a leasing standpoint, commercial leasing standpoint, would want to take into consideration. And we talk about that in the information sheet, along with insurance, of course, increased utility costs. And then if they are growing on any level that requires proof of licensure, because there are a certain number of plants that you can actually grow without having to have any licensure. But if you're doing it on a commercial level, you do have to have a licensure. So if you are renting to somebody who is growing on that kind of level, or a large number, then of course you can ask for proof of licensure that they have the proper licensure to be growing at that level. The appraisal contingency waiver addendum form has been slightly modified. I talked about this before, and we'll look at those two options quickly, but I'm not going to go over this in great detail. I do have a video out on this. that I probably need to update, because we did update this form a little bit. We do have some definitions now. We already had the buyer's cap, which, as everybody knows, is the highest price that the buyer is willing to pay. We now have what's called the appraisal gap, which is the amount over the appraisal amount that the buyer is willing to pay. So $5,000 over the appraisal amount, $10,000, whatever it is they were willing to pay. And we define ratified purchase price as the new purchase price adjusted after the appraisal per this option B. And so what you're going to see is these new terms. And then when we get to the other options, you're actually going to see a new calculation, but you just have to walk through the calculation. What we try to do with these modifications is we tried to minimize the number of spaces you had to fill in, or give you real guidance as to what numbers go in those spaces, because that's the feedback we were getting is, I'm not sure what I'm supposed to put in here. And so we have tried to kind of take care of that. You'll see in option B, which is where the buyer says you're going to pay, so much, you're going to pay X number of dollars, or so much over the appraisal gap, whichever shall be over the appraisal, whichever shall be less. Then this is option B. And of course, this is a very buyer friendly option, because the buyer's only paying so much over the appraisal gap, or another number, whichever is the lesser of the two. So what we were seeing in that crazy market that we went through over the last couple of years is we were seeing buyers making this option B, whether it be on this form or whether it be on an addendum. They were saying, buyer will pay $5,000 of the appraisal amount up to so much money. And the seller thought, oh, that's wonderful. That sounds great. They had no idea or never anticipated that the appraisal would come in really, really low. And $5,000 of that really, really low appraisal was not what the seller was willing to sell for, but they didn't counter this. And so that's what they were stuck with, selling for that low appraisal plus whatever the appraisal gap was. So remember, as a buyer, remember, this is a very buyer friendly provision, but remember, as a seller, it is not such a seller friendly provision, because that appraisal could come in low. On option C, you see the same type thing, only this is a very seller friendly, because what this is saying is that the buyer will pay $5,000 or $10,000 or whatever it is over the appraisal amount up to, or another dollar amount, whichever is greater. So if they say, I'll pay $5,000 of the appraisal amount, or I'll pay, $275,000, that means that the seller is guaranteed to get at least $275,000. If the appraisal comes in at $275,000, they're going to get whatever that appraisal gap is over the appraisal amount. So this is a very seller friendly, because the seller's going to get the higher of those two numbers opposed to the lower of those two numbers. So B is very buyer friendly. C is very seller friendly. And then when you get to D and E, these two provisions are kind of balance it out a little bit more, right? So there's a limited waiver of the appraisal contingency, and this option D creates a solid number that the seller is guaranteed to get, that they do not have to sell for anything less than that amount. So you'll see the appraisal gap language, and then you see what number we need to put in that particular space. So if you're wondering, you're going to establish, the purchase prices, whatever the parties had agreed to, whatever the buyer had put in their offer. The appraisal gap is whatever they're willing to pay over the appraisal amount. And if the property appraises for more than the purchase price minus the appraisal gap, then the buyer is going to pay the lesser of two numbers, the appraisal gap over the appraised value or the buyer's cap. And so what the buyer is saying is, I'm not going to, if it comes in over a certain dollar amount, I'm not paying more than this dollar amount, right? If it comes in at $250 or more, I'm not paying more than $260,000. Then it goes on to say, if the property appraises for less than a certain dollar amount, then the buyer shall pay the greater of the appraisal gap over the appraised value or the seller's guarantee. So this is saying that in the event it comes in below $260,000, for example, then the buyer is going to pay $5,000 over the appraised value or the seller's guarantee, whichever is the greater. So the seller is guaranteed to get the seller's guarantee. The buyer is guaranteed not to pay more than the buyer's cap. So we've set solid numbers on both ends, right? The seller we're going to know what the number is as soon as we get the appraisal in. And we're going to plug them in here, and we're going to come up with a solid number that the buyer will not pay over, and we have a solid number that the seller will not take less than. So this is option D. And again, you just have to fill in the numbers, even though there's still spaces. We've told you exactly what you put in those numbers. And then option E is similar to D, except for what this one says is that if it comes in below a certain dollar amount, if it comes in above a certain amount, so if the appraisal is for more than, let's say, $250, if it comes in for more than $250, the purchase price minus the appraisal gap, then the buyer is going to pay the lesser of the two. So much over the appraisal amount or the buyer's cap, whichever is going to be the lesser of the two. And if that happens, then the buyer will, they will solidify that price and you guys will have a new price for this. But if it comes in below a certain dollar amount, then yes, the buyer can still buy for the amount that they agreed to do so up here, which is the buyer's cap or the 5,000 over the appraisal. They still have that option. But if they don't want to pay that much, because let's say it came in for under 250 and they don't want to pay that the amount they had agreed to pay because the appraisal came in so low, then the parties are going back to the drawing board and renegotiating this whole thing. So again, it protects the seller because it says that they do not have to sell below a certain dollar amount. And if it comes in low, the parties are all going back to the drawing board unless the buyer wants to pay that, that higher amount that they agreed to pay from the beginning, even though the appraisal came in low. So you just have to fill in the amounts here. We've given you exactly what numbers should be going in those spaces. I think it'll make it an easier form to deal with. Of course, the market's changed, so we probably will not be seeing it as much. But, at one point we thought on this form about putting these A, B, C, D, E, all these options in a clause library so that you could pull them out and you put them in on an addendum and you didn't have to use a 2-page addendum for this. But the reason we didn't do this, and this is important because I've seen brokers do this since this form has been out, and I do not recommend it. We put everything on the form so that parties can see what their options are. So it's not you, the broker, making the determination or the decision as to what to use and not leaving them with any other options. I mean, if you pull out option B and you put it on a form or you write your own language, gosh, you're not supposed to do that. But if you do that and you put it on an addendum instead of using this, then the seller may not have all of their options available to them, because if they do have the option available, they will say, maybe, I don't want to use B because that's very buyer friendly. I want to use D or E where I can guarantee I'm not going to get less than a certain dollar amount, or I don't have to sell if the appraisal comes in too low. I don't have to sell for that lower dollar amount, but they don't have them in front of them to see that they have those options. Not only does it not protect them, but it doesn't protect you because ultimately you made the choice for them. You created the language without giving them alternatives. And so you could have greater liability as a result of that. So use the forms. When we create forms, there's a reason we create forms. Use the forms, and then you can walk through all of the options. Look here, we got this offer in, and it says that they want to use option B. This is what option B says. What if the appraisal comes in low? Okay, well, let's look at these other options that we have available to us, because C is going to protect you, D is going to protect you, E is going to protect you. Let's talk about those and decide which one you want to use. And let's go back with a counter offer attaching this form and saying, no, we want to use option D or E or C or whatever it is. So that's really what needs to happen in this process. So use the form. Again, it's there for your protection and the protection of the buyers and the sellers. I just want to mention one thing about appraisals, and I'm sure you're seeing this, or we're seeing this in the crazy market, and we'll see it going forward. So a traditional appraisal is obviously what we all think of, right? An appraisal assignment, which the scope of work includes the interior, exterior, personal, on-site inspection of the subject property. A desktop appraisal, an appraisal or an assignment for which the scope of work does not include field work by the appraiser, does not include reviewing a recent interior, exterior property data report. And then a hybrid is something in between. An appraisal assignment consisting of a desktop appraisal for which the scope of work includes reviewing a recent interior exterior property data report. Beginning last March, Fannie and Freddie will accept remote desktop appraisals nationwide on eligible transactions without the appraiser ever stepping foot on the property. Created with information from existing sources such as other appraisal reports, multiple listing data, public record. The property information needs to be from a participant or a source who does not hold a financial interest in the appraisal outcome. So wherever this information is coming from, can't be someone with a financial interest, and it must include a floor plan of the subject property. There are certain type transactions where this will apply to. 1-unit properties, principal residence, purchase transaction, including new construction, loan to value ratio less than or equal to 90%. And then there are ineligible transactions, which include, as you can see here, 2 to 4 unit properties, condos and co-ops, manufactured homes, construction to permanent loans, second homes, investment properties, all refis, and other specific loans. Let's talk about E&O claims, and let me just check how much time I have here before I get into this section. 11:15. Gosh, we started at 9:30. I have 15 minutes. Okay, well, this is how it went over at my legal update too. So I'm going to fly through this stuff, and then I'll let you guys go a little bit after 9:30. So, claims, we have some scary stats. The incurred amount has been more than $1 million per year for almost every year since 2012. The incurred amount over $1 million for 18. You can see 19 and 20. There's still open claims for all those years, so these amounts are expected to increase. So far for 2021 is 966 paid out in claims, but there are 50 open claims from 2021. So we anticipate even more. 2022 is up to 178, but there are 85 claims so far. So that's going to peak over $1 million as well. We have the highest number of claims of any state that Rice services. So Rice is our state provider of E&O. It means that if you get a claim, you can't be canceled or they can't cancel your policy. It means that your insurance rates are not going to go up as a result of a claim. They're the only company that bids every time consistently bids our state coverage. If we don't have state coverage, then brokers are not going to be required to carry E&O coverage. You can still carry E&O coverage, but you won't be required to do so, which I'm sure all of you on this call today would not even think about practicing real estate without E&O coverage. But unfortunately, there may be some brokers that don't carry E&O coverage. And of course, that would be nothing but bad for consumers. So there are currently just over 6,000 licensees enrolled in the program. Some are enrolled in other outside insurance companies. Crest is another big one here in the state. So amount paid out in a given year, $1 million. The average amount per licensee, 167. Like I said, of all the 15 states, New Mexico's got the highest. Our current price is $349. It will probably go up to $366 the next year. But Rice has not received the contract yet, but it does sound like they're bidding it again. So that's all good news. So recent comments from Rice suggested I'd like to share with you these information about claims and reporting what constitutes a claim insurers think is only lawsuits, and that's not true. It's very, very important. And I tell people this all the time. Let them tell you you've called them too soon. If you get a threat of litigation or a demand letter, then you need to notify your E&O carrier immediately. Otherwise, it will jeopardize your coverage. So let them tell you that you're reporting it too soon. Reporting deadlines, 20 days for regular complaints and subpoenas, up to 90 days for claims. A lot of claims are actually denied because they were not timely reported. And report claims to Rice before responding to the claimant so as to not jeopardize your coverage. Okay, so you have to do this in writing as well. Report a negligent act that could become a claim when it happens. Insurers occasionally run afoul of prior notice provision. So you know that you did something wrong. You know it could turn into a lawsuit. Let them know about it. Reporting does not affect individual premiums. As I said, they can't be canceled. They can't be increased. It does because it's the state offered. Now, if you have Crest, that's not true. They can cancel you if you have Crest or another E&O coverage or with another company. They can also increase your rates, but not Rice. Rice will not do that. And the policy does not reimburse for reporting agreements to pay money or reduce commissions. So obviously, if you're going to write out checks or reduce your commissions as a result of something you think you did wrong, the policy will not reimburse you for that. Now that the market's slowing, we're seeing more claims from sellers when a transaction does not close. And then sometimes sells to the next buyer at a lower price. And on the flip side, they're also seeing claims from unhappy buyers, as I said earlier, people that waived inspections, contingencies of all sorts are now having buyer's remorse, and they're seeing those claims now. We have claims where licensees forgets to ensure that a second addendum makes it clear whether the first addendum is null and void. Remember that language I talked to you about in our addendum about how prior addendums work. You really need to be clear about that. In some case, if it's not clear, then we don't know if that's an addition to or if it takes the place of, right? This is the language that we talked about in our resolution addendum. We're being very clear about whether it takes the place of prior addendum when it comes to seller repairs or seller credits. That's very important, but a lot of addendum that brokers are drafting do not address that. We've also had claims alleging the addendum language was vague or ambiguous. Recommend buyers and sellers get attorneys. I got a call from somebody the other day on the hotline, and they said that our forms were so complicated, it was driving their buyer to an attorney, and it was going to ruin the relationship between the broker and the consumer. And I said, well, I explain why our forms look like they do, but this idea that you guys have to be everything for everybody in the transaction is just misplaced. There are roles that sometimes, other people have to play. That appraisers have to be involved and inspectors have to be involved and surveyors have to be involved. And, all of these different players that come in, and the idea that an attorney has no role in a transaction It's just, it's just, that's silly. It's just absolutely silly. These are contracts. So, we try to make them, write them in a way that doesn't send people to attorneys, because it answers so many questions that you're not left asking, what does this mean? What does this mean? Because if the contract doesn't ask it, I can assure you they're going to go ask the attorney what it means. We try to address all those questions so the attorneys don't have to be involved, in the purchase agreement does answer all those questions. But if you have a buyer who doesn't like our contract and has to be have an attorney draft something for them, I can assure you that's not going to keep them from coming back to the brokers and getting the brokers help, because you guys do something very different than that. And, in my private practice, when I'm asked to draft a contract for somebody, I make it very clear to them, I'll draft the contract. I handle the legal aspect of this transaction for you. I will not be helping you through the transaction like a broker will. You need a broker to do those kind of things for you. That's what brokers do, and they do it well. So, just don't be afraid to say, we need an addendum. We need a counteroffer. This is complicated language. You guys aren't trained to write that language, and you should be sending them off to an attorney to handle it. Confirm important conversations. I talked about this in great detail at my last presentation, so I'm not getting into it. But these are, again, things that are coming back from the Rice Company investigators and assessors, and these are the things that they're seeing. If sending multiple offers or backup offers by email, inform the seller that only accepted offers should be signed. When dealing with out-of-town brokers, make it clear that the broker is not acting as your eyes and ears. It's the condition of the property. The property manager should investigate whether there are options for bodily injury and property damage, because, again, you have no coverage under Rice for bodily injury or property damage. So I've told you guys before, look into alternative coverage for those things. Importance of having a survey for vacant land and being clear that the buyer should satisfy themselves with the location of the property. Can't tell you the number of times the wrong property has been sold. Number of times. Buyer suing for seller and listing broker non-disclosure despite waiving the inspections. See what I tell you? They're suing the brokers because they waive their inspections. Misrepresentation, lack of knowledge about locations of utilities and water with respect to vacant land. Non-disclosure allegations against listing broker who is property manager of the same property prior to the sale. If you're a property manager, you probably know a few things about the property, right? Inaccurate or vague descriptions in the MLS. If you make representations, you can't then rely on the buyer to do their due diligence. In other words, if you don't say anything about something, then you can put the ball in the buyer's court to go figure it out if you don't have the answer. But if you make an affirmative representation about something, for example, the utilities come to the property line, you're going to be bound by that, right? You're going to be, and you're going to get in trouble if that's not a true statement. I just want to make quickly a comment about our new seller disclosure form. Our seller disclosure form used to be very pro-buyer, lots of great information for buyers, exposed the seller to a tremendous amount of liability because they were providing all sorts of information not required by law that they provide. And boy, they should better not get it wrong. So we went in another direction and we tried to move the seller's requirements for disclosure closer to what you guys have, which is adverse material facts. But that form we're finding is not providing much of any information to a buyer. I think in part the reason that's happening is because you as brokers have been told for years, don't touch the property disclosure form, hand it to your seller and don't go anywhere near it. You have to go near this form. You have to have conversations with your seller about how to use this form, right? But we are working on revisions to this form that should be out here soon that will assist. So we are going to be putting check boxes that say yes or no. So we are going to start listing adverse material facts within the body of the adverse material facts forms and asking for yes or no. Is this wrong? Is this wrong? Is this wrong? We're not going to cover everything because that's impossible, right? But we are going to get them a whole lot more examples, and we are going to require yes or no answers in there. So that should really help them. And then we have a cover sheet. And one of the things that is very important, you'll see a lot of kind of new direction or instructions to the seller on this cover sheet that's going to go with it. But one of the things that comes up all the time with the adverse material facts form is, what if I had something fixed as a seller? What if I have something fixed? Is that something I have to disclose? And this is what it says about this. And I've actually expanded on it even slightly more since I wrote this and put it on the screen. But it says that if an adverse material fact previously existed, but has been repaired or replaced, so it's no longer an adverse material fact, the seller is not required to disclose the issue provided. So however, Seller, you better be confident that the repair or replacement has fully and completely remedied the issue, because if you elect not to disclose the issue and it's later revealed that the repair or replacement did not fully and completely remedy the issue, you may be liable for your failure to disclose. So there's a whole section about this issue of I got it fixed, because a lot of sellers will get things fixed for purposes of putting it on the market. And let's say they got the roof fixed and we haven't had any rain, which happens in New Mexico, except for the last, I don't know what, month or more, because I feel like I live in Seattle now. But it really, a lot of times we don't get rain for long periods of time. So you fix the roof, but you haven't really had an opportunity to live with that fix, because we haven't had a big downpour since you got the roof fixed. So disclose the fact that you have gotten, that there was a roof issue, and then disclose the fact that it was fixed, and let the buyer get their roofer up there to confirm that the fix actually took. Because if that roof was not actually fixed and the buyer moves in, it starts raining and the seller says, yeah, I thought it was fixed. Well, guess what? It wasn't fixed. And guess what the buyer's going to do? They're going to be coming back to you, seller, as a result. So another sentence that I've added to this is that it is prudent to provide them with the information about what was wrong, how it has been fixed, and allow the buyer to do their own investigation of the fix to make sure that it was done adequately. So between these additional changes, these changes we made to the adverse material facts form, I think we're going to get more, but listing brokers, you are still need to be helping your sellers with this form, not answering questions for them, but helping them think through the form, helping them think through how to fill it out. The whole cover page talks about adverse material facts and actual knowledge, and that it's not an excuse that you didn't live in the property. So maybe you don't know anything because you didn't live in the property, but just because you lived in the property doesn't mean you don't know anything about the property. If you were paying your property manager all these years for different repairs that had to be done, you probably know something. If you were a flipper and took everything down to the studs, you probably know something. So just the fact you didn't live in the property doesn't mean you don't know things about the property. So again, the cover sheet will give a lot more direction on how to use this form to the seller and to the brokers. And then we also go on, of course, to tell them that they have an ongoing obligation to update the form as necessary. And we talked earlier about the deadlines for objecting to those updated adverse material facts that the seller may provide. Insureds can jeopardize their coverage for future claims if they start making promises to pay more, reduce commissions, assume obligations in order to keep a deal together. These are all things I know you want to do because you want the deal to work, and you're sorry that something happened. But again, it jeopardizes your coverage to start doing those things. The whole idea of reasonable care, ethical and professional conduct, very broad, right? So it opens the insureds up to negligent claims, especially as there's no stated limitation to the duties. And this is the case that I talked about the should have known. So I think, we continuously have to, at some point, we're going to have to probably challenge this in order to get that case overturned, hopefully get it overturned, so that you guys are only charged with what you should know or what you do know and not what you should know. So, but that requires them to not pay out on the claim and to litigate it through the district court and through the appellate court. And that's expensive. And that's why they don't do it. That's why they just settle the claim instead of trying to fight it. So I hope at some point they do fight it. So there's a lot of information here about claims. I know I'm running out of time. Just some stats, 17 to 22 reasons that coverage was denied. Late reporting was one of the biggest, as you can see here. Bodily injury and personal was 14%. Somebody trips down a flight of stairs or hurts himself in the backyard, falls in a hole. You don't have coverage for that in Rice. That's why I'm always telling you guys to look for alternative coverage for that. Personal interest, outside professional services, prior acts. And it goes on here to tell you I'm not going to be able to get into this because I'm running out of time, but what it means to be a personal interest. I will say that you have some coverage for some owned or purchased property that you have. So professional services relating to property in which any of the following had more than a 10% owner or financial interest: an insured spouse, insured domestic partner, or any entity, the partnership or trust in which the insured or insured spouse has a 10% ownership. So it excludes these kind of coverages. And that's why, and professional services too. So there are exclusions, and it's important that you guys look at your policy, see what's included and what's excluded from your policy so that you can look at alternative insurances. I'm at 11:29, so I probably have about 5 more minutes. I'd like, if you guys will have access, you guys will have access to this, so you guys can take a look at some additional reasons for claims that are being denied outside professional services. I go into all of those. I also have a few cases that I want to talk to you about, and then I'll let you guys go for the day. So during the morning after winter storm, a plaintiff, a prospective buyer, slipped on a driveway of a vacant home and suffered injuries prior to a showing. The injured buyer filed suit against the homeowners and the listing brokerage, claiming the defendants failed to provide adequate warning of the icy conditions and failed to remedy the hazardous conditions. The defendant broker's agent was not present at the time. So the listing broker was not, the buyer's broker was not there at the time. The listing broker was not there at the time, and the homeowners were no longer occupying the property. So no listing broker, no homeowner. The defendant brokerage moved for summary judgment as a matter of law, arguing it did not owe a duty of reasonable care because it did not own or possess the property. The trial court denied the defendant's brokerage's motion for summary judgment, reasoning that a juror could find that the brokerage had knowledge, the brokerage meaning the listing brokerage, had knowledge of the hazard and should have exercised reasonable care to ensure the conditions of the driveway and exterior walkways were safe. And the Supreme Court granted interlocutory review, which meant that they could go up to the Supreme Court to have the issue reviewed. And they concluded that the homeowners and not the brokerage retained immediate authority and control, and the brokerage's mere involvement in helping to sell the property did not amount to possession, and the court did not believe that merely scheduling a showing with a potential buyer transferred the property's control. And they held that the right to enter is not the equivalent of possession, and it reversed the trial court's denial of summary judgment. And the opinion referenced how imposing such a duty on a listing broker would significantly impact an agency's risk mitigation steps while also increasing costs to the consumers. And the court likened a listing broker's control over a home to a neighbor who has left keys by a vacating owner. But the court did distinguish its holding from other cases where the courts have held that when a broker is present during a showing, that they are in possession. Okay, so that's distinction that they made at this level. Now, this wasn't a New Mexico case, but it's still relevant to look at other jurisdictions to see how they've handled these type cases. So in this case, the listing broker was not present, but in the event that they had been present, they would have had a duty of reasonable care to ensure the safety of the prospective buyers. But since they were not, they did not. So that was what the Iowa Supreme Court held. And these are the takeaways. Discuss ways to mitigate any obvious or known hazards that exist on the property with the owner prior to showing, and take reasonable precautions to protect prospective buyers and others from hazards. Consider delaying in-person showings if dangerous weather conditions or hazards exist. Review insurance policies, again, to make sure you have coverage, and follow these realtor safety tips when entering a vacant property for showing. This one is interesting because up in Washington, they actually passed a law that said that buyers could not submit love letters, because as we talked about before, when we talk about love letters, they have the potential of having sellers read the love letters, ascertaining what class of people, protected class that a particular buyer may be part of, and then discriminating against that buyer because they are a member of that protected class. So there was actually a legislator actually passed a law prohibiting love letters up in Washington that was challenged on a First Amendment basis, saying that it interfered with a buyer's First Amendment right to write a love letter, and it was overturned. The Supreme Court agreed and said that the law needed to go away. And so it's unenforceable, the law that they have, and they're going to take it off the books because the courts ruled, the highest court there ruled that the buyers have a First Amendment right to write love letters. So, and let me get to the last, I think this is the last case that I'm talking about today. Second Circuit Court of Appeals. Again, that's not in our district, but it's always helpful to look around. This has to do with a hotel website's failure to include information in violation of regulations developed pursuant to the Americans with Disability Act. So I've talked about a lot about your websites. If you have public facing websites, I've said, a couple of things. Number one, copyright infringement, which is huge right now. We've been fighting several lawsuits in the state. Various people have been fighting them, and we've been assisting in one of them, where a broker, entity actually uploaded a an image that a photographer claimed was a violation, was their image, and they said it violated their copyright, and they made a demand for $30,000. And that has happened to multiple brokers here. So I've been talking about making sure that whatever's on your website, you either took the picture or you have the proper licensure to use it. Make sure that that's the case. The other thing I've been talking about is the ADA lawsuits, because the Supreme Court has determined that a public-facing website, whether it be your brokerage's website, your own personal website, that is a place of public accommodation that requires that people with disabilities are able to access it. So, you know, if they have reading disabilities or if they have visual disabilities or that kind of thing. However, in this particular case, we're seeing as a result of course, of these decisions, we're seeing a whole lot of abuse. And in this particular case, this person was known as a tester who was going around trying to find websites that weren't in compliance. And the court actually ended up dismissing the case and basically telling them that they do not have standing to bring ADA accessibility claims without showing an actual or imminent personal and particularized injury. So you actually have to show your injury in order to bring that websuit or lawsuit. But again, website accessibility is, is a big topic right now, and making sure that your website is compliant with ADA standards is very important. So I encourage you, if you have public-facing websites, please talk to your website providers and make sure that your websites are ADA accessible. In this case, they said this particular tester did not have a right to do it. They don't like to see the abuse of the system, but at the same time, where they do have standing, they are finding violations of the ADA because that's because they don't have the websites are not available or made available for use by people with disabilities. This had to do with a New Jersey court which upheld that the constitutionality of a Jersey city ordinance that restricts private property owners' use of residential properties as short-term rentals. And the court found that the ordinance was allowed. So they can, a municipality can, and I know that you have this up here, up in Santa Fe and other areas of the state where they do put restrictions on ordinances that say, no Airbnbs or nothing less than a 60-day, rental, is allowed, or nothing more than 60-day of rental nights per year. And in this particular case, they found that the this ordinance or this jurisdiction, the county or the city that had this, were within their right to pass such a provision. So if you're dealing with that, that's not good news. But the realtors are always fighting these type cases that deal with taking away private property rights. And so that was not a good, not a good outcome for realtors and for private property rights. Texting lawsuit. If you guys are texting, make sure that you guys have permission to text. I'm going to leave that available for you guys to read later as well. Please, I'm not going to get into this because we got to go. Please, if you haven't read my article on don't use this term as is, don't use language like that in your offers or your counter offers. If you haven't read that article, please do. I cannot tell you the number of times that this has come up on the hotline. And every time I get a call now, I say, you didn't read my article, did you? If you need a copy of it, I know that NMAR is going to make all of my latest articles available online. So please read them. It just keeps coming up. Even now, it keeps coming up. So I can't get into this now, but I have a whole article about, inspections for informational purposes only, as is language, all of that. So make sure you get that. I also have a language on the copyright infringement that I mentioned a minute ago. I'll make sure that those are available to you again. So if you miss those, make sure you're on NMAR's email list so that you are getting the NMAR voice. Because the NMAR voice is where I write these articles. It comes out the first or second week after the end of every quarter. And it has lots of great information about what's going on with the association and things that are happening nationally. But it also has a section that I write, and it's always something that's relevant to you guys. So please get a hold of that and read it, because you'd be amazed at the number of calls I get after I write an article. And I'm afraid too many people are missing these articles. So I talk all about copyright infringement and all of the issues we've been dealing with on that front. I just quickly mentioned title insurance. I'm sure you guys have seen this warning on your title policies. Please be aware that due to the conflict between federal and state law concerning cultivation, distribution, manufacture, and sale of marijuana, the company is not able to issue insurance on the transaction if that's what the property is being used for. This you're seeing on title insurance policies. And I talked to one of my friends, my colleagues, who is an underwriter. He's an attorney underwriter for one of the big companies here in the state. And I said, you know, you don't ask the question. You don't ask the question about whether or not the property is being used for this purpose, but you have this notice on there. In his opinion, when you see this, what they want you to do is to share the information if that's what it's being used for. So the conversation needs to be had with your buyer about whether or not that information be shared. But because it doesn't explicitly ask, and I pointed that out to him, you don't explicitly ask the question. So you imply that you want the answer, but you don't explicitly ask the question. So I'm not suggesting you guys volunteer the information without talking to your buyers, but it could ultimately have a problem, create an issue with their title insurance if that's how they're using the property and it's not disclosed. So it's worth knowing. If you guys have questions about anything I went over here today, I encourage you to call me or email me on the legal hotline. There's a number here on your screen and also the email address. I want to thank you so much for coming today. And I hope you guys have a wonderful rest of the week.
Thank you, Ashley. Thanks everybody for logging in today. We appreciate it. Again, the certificates will go out to all attendees after everything has been verified. You guys enjoy the rest of your wonderful day, and we'll talk to you all soon.
Thank you, everybody.